Welcome to another Bytes with Beck and Benji. Thanks for joining us. Today's discussion is with Chris Sibree, who is the head of legal from CyberCX, Australia and New Zealand's preeminent cybersecurity company. The conversation will be centered around the legal considerations of AI, including the different legislative approaches to AI around the world, discussion of copyright in the age of AI, implications of voice cloning, and much more. This conversation is not legal advice and is not intended to be legal advice. It is provided as general information only. Seek your own legal advice as relevant to your particular situation and needs. Over to you, Beck, Benji, and Chris.
Hey everybody, welcome again to the second episode of Bytes with Beck and Benji. I'm Benji, and with me as always is my colleague Beck.
Hello.
Today we'll be having a lovely conversation about legal considerations of AI with our esteemed guest and head of legal at CyberCX, Chris Sibree.
Nice to meet you all. Thanks for coming along.
Thanks for coming.
Yeah, great to be here. Looking forward to it.
Absolutely. So, Chris, you've, I believe, been attending a number of talks about the space at the moment, how it's evolving with generative AI. And I think that it's a very timely conversation to be having, given that so many places around the world are actually having discussions around how to legally approach these things in different jurisdictions and how kind of each government has had their own criteria for looking at how they're looking to roll out these legislations.
Yeah.
Do you have any insight as to how disparate the approach has been?
Yeah, no, thank you. It is absolutely a hot topic at the moment for all the right reasons. AI has garnered so much attention, generative AI in particular, since the launch of ChatGPT, which was only about 16, 18 months ago now. And it's amazing to think that was such a short time. And if I heard someone on a podcast recently say that even if there was no development of that tool from that time, it'd probably still take 5 years to work out all its capability. But the reality is things have increased and grown at an exponential rate since then.
The user base is huge for ChatGPT.
User base is huge. I think you saw an explosion of people sign up. I think it's the fastest number of sign-ups on a platform or an app to get to a million or 10 million, et cetera, et cetera.
Yeah, well, it's 2 months to...
So ChatGPT reached 100 million active users within 2 months. In 2 months, that's actually the highest adoption rate of any application in the past 10 years. Yeah. And for context, Facebook took 4.5 years to achieve that.
Yeah.
So the scale of adoption is massive. I think the other consideration with and particularly your expertise with regards to the workplace using these things in different contexts is if the adoption rates are so high, it's probably safe to assume employees within organizations are using generative AI within their workflows. What's the considerations that, a general employee that might be interested in using these tools in their workplace, what should they be considering before they just jump headfirst?
Yeah, I mean, I think first and foremost, you're probably always good to understand what Gen AI is and what it's based on. And there's there's underlying models. So GPT-4 is a model, BARD is a model, AMD is a model, and then the generative AI is is tools and applications that output things based on inputs you provided. So that might be text, it might be visuals. Now there's text to movies, all sorts of amazing developments going on. So obviously, lots of people have played with this stuff. And no doubt lots of employees are playing with this stuff in the workplace. And so employers are facing into the reality that this is going to be very much part of their ongoing concern and a risk to manage like every other risk. For employees, I think the guidance generally would be you need to understand that it should be used just as research. It should be used to form, maybe test or understand things, summarize things, do a little bit of preliminary research or investigation on something, but it cannot be your final outcome.
See the information.
Exactly. Yeah. Or maybe you've already, it's a really effective tool for doing, hey, look, I've got this 20-page article. Can you summarize it for me in 5 dot points? It's a time-saving tool in many ways. So a great productivity tool. But it cannot be, and like as a lawyer, I see this all the time, it can't be something that replaces your professional judgment and what you're there to do. Your skills, your professional education, your knowledge base. It just has it's another useful tool in your armory, perhaps, to get to an outcome.
And there's been a lot of cases around the world, hasn't there, where in the courtroom, there has been examples of it being used for in instead of somebody's legal mind.
Absolutely. I mean, there's some really great cases out there, both in the US, the UK, Canada. Probably one of the more famous ones was a case involving one of Trump's old lawyers, Michael Cohen, in a case he was part of, that they submitted evidence into court, or submissions into court, which are effectively signed off as, I guarantee these things are correct to the best of my knowledge, and subject to perjury. It made up links, made up court citations, made up judgments, rulings.
I believe as well, it made the defendant the plaintiff and vice versa. It switched on people.
And when you produced a summary of the court, what the court outcome was in the case that had been made up, when you read through it, sort of, you would have tweaked. It's a bit of a word jargon in some ways. It on the surface, it looks like a legal document or something a lawyer might do or a judge might say. But when you actually read into it and thought about it, it was clearly something that would
know what you're talking about from a legal perspective.
Exactly.
And I think that particular case, the world at large would have looked at it and gone, well, of course it was that guy. We're not really expecting much, but it's happened so many more times in different countries.
Yeah. So it wasn't he was actually his lawyers, but he's the sort of highlight association. It's definitely happened in a range of other cases. And I mean, I think the thing you've got to remember is you don't absolve yourself of responsibility. As a lawyer, you are responsible for what you submit in court and for what you do for clients. And so, in a number of cases, their clients' cases then got dismissed and fell over. And those lawyers got reprimanded, suspended, fired, etc. Because obviously it's a breach of ethical duties, legal duties, a number of other duties for a lawyer. That's no different to in your workplace. Because if you're producing something that's going to a client, say, and that's just come out of a ChatGPT type sort of Gen AI tool, then there's no guarantee what's in there is actually correct, number one. So there's sort of an accuracy issue. There is also a question of what's that tool or what that model has been trained on.
So they only know what data they've been fed.
Yeah.
Expecting them to, I suppose, be able to answer something beyond their training data set or beyond the bias that they may have learned from that data set is basically impossible.
I love this term.
Yes, and that's why they hallucinate, because they're like, oh, I want to please you and tell them an answer. But I don't know.
Yeah. I mean, we call it hallucination or hallucinating, but realistically, it's just making stuff up, right? That's all we call it in layman's terms, making stuff up. And obviously, if you're making stuff up, then, you're going to be in the typical area. So, there's no doubt there's massive productivity gains to be made. And there's a lot of parts of everyone's job, my job included, which, is a bit of a grind, right?
Yes.
And there are definitely going to be AI developments that help to remove that grind and make that grind more productive.
Absolutely.
And there's going to be things that do fantastic outcomes for customers, clients, presentations, marketing, etc. But it cannot replace, a good professional judgment and review.
Yeah, I think things like, data into visualization, automated repetitive topics and tasks, things like that are kind of good, but trying to make the argument for you or do the research.
Yeah.
No.
I think also we're seeing only the first round of this. These are very much consumer-facing tools, and they're the ones that grab the headlines.
What's the most interesting about is OpenAI was initially a research and not-for-profit company, which has now clearly moved into the very real competition space. I think, when looking at things like legal services or professional financial services more broadly, automating those bottom level or like lower thinking tasks to allow you to focus on the more highly skilled thinking, critical analysis stuff, that's where this stuff really comes into its own, is it allows you to not replace you, but replace the parts of your job that arguably you can spend less time on, so you focus on the more important things.
Yeah, it's that old, I think, the great expression is, AI won't replace you, but someone leveraging and using AI will.
Yes.
Will, correct. And I mean, here at CyberCX, and Friendly Phishing is part of the CyberCX group, we're looking at ways in which we can leverage AI to do things a bit more efficiently. So, for example, tried and tested part of every lawyer's day job is looking at NDAs. NDAs come in all the time. No one really wants to spend any time looking at NDAs, and really they're just a ticket to the dance to allow you to have a more developed conversation with someone about an outcome they need. an AI tool could be very effective at just doing a quick first pass on that and calling out things that look like it's kind of not in your risk, in how you accept or delineate your risk across your portfolio. Now, obviously, that would just be maybe that's the first 50% of the job done, and then the rest of the job should get done by, a lawyer or someone else skilled in doing those sort of things. And no doubt there's lots of other use cases like that. Absolutely.
I mean, the point that you brought up about the gentleman that used GPT to generate the case documents for the court, it strikes me as similar to if you were to use any other tool that we use in a workflow, for example, even just Word, and you wrote something out and then never reviewed it but submitted that to court. The accountability and I suppose responsibility for you having submitted that thing and not reviewed it is equal whether it came from a GPT or came from you. The impetus is still on you as the lawyer, professional person hired. I've noted all that's in line. So the transparency, accountability, and I suppose ethical management of how to use these tools is also, I would argue, very important as to how to roll them into your workflow.
Yeah, absolutely. I mean, coming back to some of the legal aspects as well, first and foremost, you've got to remember these tools are ingesting huge amounts of publicly available data to train themselves on. Now, there's some interesting legal questions around that because some of that data, some of that information could be personal, but could be subject to copyright or trademark and those types of things. They will not necessarily have a license to use that copyright in that way and ingest it and process it in that way, potentially, number one. So secondly, if some kind of output from that also contains some of that copyrighted information or that protected information, then potentially your use of that information could also be in breach of copyright or other legal protections as well. On the reverse, sorry.
No, you go.
On the reverse, if you're using these tools and putting in a whole lot of information that's either confidential or subject to copyright of your organization, then once it's in it, you can't get it back out. Right? It goes into its vast sort of universe of stuff that's sifted through and uses to train the model further. So a great case was a bunch of engineers put some of their code in, from I think Samsung with their code in ChatGPT, without really realizing this or being alive to the issues. And once it's in, if you do the right type of prompt engineering scripting into chat, you can probably find the code. Now, that obviously meant that Samsung then banned their employees using it and had a very sort of, I'm going to hit it with a hammer type approach to it.
The skyline.
But obviously they had no awareness of the issues and the implications of doing things in that way.
I think people are still uncovering things like that. I mean, prompt injection attacks and just general experimenting with how you can get beyond that initial layer that they provide the users in ChatGPT and just LLMs generally. It's becoming a whole, I suppose, hobbyist tinkerer, security interest of a large part of the user base where
it's like a pen tester game.
Exactly. So who knows how much of this information that was submitted in 2021 when this was a bright, shiny new thing and no one was thinking about any of these things, what could come up in 2024 that, it was just sitting in the data set. We didn't.
But also what's fake about that as well. I mean, it doesn't know how to discern how to use the information. It just knows, you're talking about this kind of matches up. I'm going to put this into a narrative for you and serve it up. And so where copyright infringement stuff comes along, like you said, Benji, you've got a lot of historical data and a lot of historical information. How do you end up proving that? I mean, if you were to say, okay, your version of ChatGPT just spat out my personal copyrighted.
Yeah, I don't know if we've really seen any test cases around this at the moment. It'd be quite interesting to see because I imagine there would definitely be companies who would be willing to take those people on. There's a huge amount of competition in this space, but there's also a huge amount of antagonism to some of the
But also I suppose if it was to take to court, there's also the proprietary information on how it built, what it's actually been fed as well. So you've got a couple of layers there of that privacy.
I think that's right. I mean, if you think about if you had sensitive information being utilized or inputted into there, or it's been traded on sensitive information, health information, personal information, then there's all sorts of implications for the individual involved. We've seen, obviously, our space, we deal with a large number of data breaches every year, which sometimes involve quite sensitive personal information. of particular data subjects, with health organisations, hospitals, and these types of places. And that can be hugely concerning for people.
Absolutely.
Well, yeah, for patients who are in the hospital, who've been in those hospitals, maybe it's in relation to mental health issues and those types of things. And there's all sorts of concerns about how they could be leveraged against those individuals.
Well, I know in the US there was some extortion happening with some of the health information coming out, which was extremely distressing.
Yeah, and when we had the big Medibank hack in Australia over the last sort of year or so, there was a thought that they had been quite selective. It appeared that attacks had been quite selective about how they targeted particular high-profile people with potentially finding information that would be embarrassing for them or put them at risk. And thankfully, the media did a great job of not republishing or turning that into a publication. And wasn't very hard. No, and hard to find. People know where they're looking on a particular dark web areas.
I think the main concern with the medical stuff is it's you can't change it. Like that's tied to for life, and it's unlikely to go anywhere. So those things are very much locked elements of your PII, as opposed to something like your driver's license number or your credit card, which these things are easily replaceable. Should there be an instance where we need to?
Which also then, when you think about where these models are, the data sets these models are using, it also then makes, at an individual level, makes you think, okay, and reflect on what is the information about myself that's out there.
What's your digital footprint?
What's my digital footprint? What photos am I putting on the internet publicly? What other?
Think about Facebook from the first 2 years it existed. I mean, people were just putting dumps of their entire memory
back to 2007, 17 years ago. Do you remember what you were putting into Facebook 17 years ago? Because Facebook does. They still have it on a server somewhere,
that's
right?
Of reasonable to be.
That's it. That's it.
If you think about photos of yourself with a license or a passport, photos of kids, all these compromise.
Plane tickets, all that kind of stuff.
Yeah, speaking about all the stuff, I recently moved house in the last couple of months, and going through the rental application they wanted, a driver's license and then a proof of bank balance and all this. I was basically leaking personal information everywhere, submitting it to all these different people and different sites. And
to that online platform.
Because they're all online platforms, and you're kind of assuming, okay, well, it says it will be deleted in 60 days. Fingers crossed it will. I mean, I don't have any oversight.
60 days of opportunity there, though. That's the thing.
And then, there's another interesting aspect of this from a link perspective, which is something that is created by a computer-generated innovation or inventions, is that able to be protected? Can you get a patent for something that's generated by?
Can copyright something that has been produced?
Exactly, and I mean, quite interesting. Australian courts were quite early in the piece in terms of considering this issue, and eventually came down the side that it has to have some level of human. It has to be an individual or a business or legal entity that has a role to play before something can be patentable. So that's been quite interesting, but no doubt. Coming to your question earlier around different jurisdictions, how different places across the world dealing with these things, that no doubt the Australian courts, now have taken a particular approach that might be different to the approaches taken in other jurisdictions, because everyone's got slightly different approaches to IP protection.
And I'm actually very curious on your thoughts around with some of these data sets and the models that come out of them. So if we use, for example, OpenAI as a model that scrapes the public internet and then trains itself on that. If you were to compare that to, say, for example, Adobe's AI models and data models that they're producing at the moment, given that that's all trained on proprietary licensed Adobe material, they don't do it on anything but stuff they own, is that a different consideration that they actually do have the full copyright of those materials?
Yes, absolutely. I mean, I think this is where a lot of organizations are going to start looking at an enterprise. Those companies that can afford it, they'll have much more of a closed model, right? So if you think about a very large bank, big investment banks where they've just got, years and years of analysts, research and reports and all sorts of stuff, you can see the power of being able to train something on that, and then you allow an analyst or someone who's researching a particular stock or movement, some trends, to say, can you give me a summary of the last 20 years of our internal research on oil prices in blah, right? or the price of oranges in California, and it would be really incredibly powerful at doing that.
Yeah.
That's obviously harder for smaller companies, right? Because they don't have the capability or the resources to create their own sort of tool set or data set to do these on. And I'm no doubt this is where some of this will go, and that there'll be more offerings for businesses so that they are comfortable with settings from a legal perspective about, okay, how's it been trained? What sort of data is it ingesting? Where's our data going to go? And then I'll get a bit more comfortable. And I liken this to, I've been around long enough to remember when, technology lawyers did a lot of time doing long-term licenses of, a big on-prem type license that can load it up, and then you'd buy the maintenance support, and that would be obviously an ongoing thing. Over time, that started moving to this thing called the cloud. Everyone's a bit, what's this mean? And there was definitely companies that said, we don't want to have any of our data put in the cloud. Now you wouldn't find a company that doesn't have data in the cloud, basically. Now, there's obviously risks with that, but there's huge benefits as well. You almost accept those risks as part of the bat. Yeah, and that's because it's evolved. People got comfortable with it. There have been protections. There's been better security, been better segregation, whatever it happens to be. No doubt this space will keep moving in that direction to evolve to meet those needs of particular clients. But, time needs settle.
That leads me to another question I have, which, given that all these models are trained on like such massive amounts of data, the conversation that I see kind of happening on the periphery with more AI experts, and less the, I guess, general technology hobbyists, is not a long enough timeline, because these models will learn from publicly scraped data. If we're using GPTs to generate data, and then they're going to learn from that data again,
it's going to eat its own tail.
They're going to eat its own tail. It's actually been referred to as a phenomenon by a gentleman named Jathan Sadowski, and it's referred to as the Habsburg AI. Habsburg are the German royal family, if you might know, who they get married into so many families of it, and you notice the Habsburg chin, because it's a genetic trait that was very strong. This is a similar thing. So the phenomenon is that you become such a heavily inbred mutant with exaggerated features and training and biases that how does one then kind of address those moving forward into the future part of all of this?
Well, particularly as companies and individuals become more aware of the risks of their stuff being ingested as a training, part of the training of the tools, right? So people will work out ways of ensuring that stuff doesn't get ingested in, right? And so you become, I can see this be quite an interesting challenge to solve. Now, the fact is, when you've got people like Microsoft and Google and stuff trying to solve these problems, they'll probably work out a solution.
Yes.
But yes,
or effectively provide the options and really only give you one.
Yeah, I mean, junk in, junk out. That's it. And look, most of these models only go back so far in terms of the years that the data they've looked at. So they have a very limited understanding, and again, you come back to the hallucination problem.
I guess that's where those closed systems are probably the biggest benefit. So if big companies have a lot of data, having that closed system, it's not on the internet, it doesn't have access to anything else, that would be a lot more valuable. But then you look at things like Google, who are, the biggest thing ever, and they've got their new Gemini, and it's using BigQuery, it's using Lambda, it's using anything it can, and that's a scary one.
Yeah, absolutely. I think so it comes to the idea of how are different sort of countries looking at regulating this space. It's quite an interesting question. It's a lot of development over the last 5 years, particularly the last 3 years. 5 months, this is the last 2 weeks, right? So, Australia definitely has, put a foot forward and started looking at it. But I'll talk mostly, the big movers are really going to be the US and the EU, right? They're the big markets. And there's definitely others. China's definitely taken an approach. There's lots of approaches, but it's quite interesting. They're taking quite different approaches. In my interpretation of what's happening is the US came out with a set some sort of executive orders, and effectively they had buy-in, or sort of a voluntary buy-in, as it were, from many of the very, very large sort of providers or model owners or developers. So people like OpenAI and Microsoft and those types of the world, and putting in some controls and some obligations on them around about how their tools work, and transparency, testing, etc. That's to contrast with the EU. So, instead of going after a very small number of very large companies, they've taken a risk-based approach. So they're now considering AI about how high risk is that use? Is either high risk use things, so things that do social engineering, those types of things, versus more moderate or low risk cases, and there'll be different obligations and different rules that apply to each type of risk category. Interestingly, that just got passed by the European Parliament this month, so that will come into effect over the next sort of 12 months, generally speaking, and it'll be a different model, right? And it'll be quite interesting because you'll have companies having to work out how they navigate through this at a global level, and there's companies so global, right? So how do they both comply with the US sort of obligations? If you're one of those sort of small number of very, very large sort of tech players, versus maybe all these sort of very nimble people who are trying to evolve what they're doing based off the capabilities of the AI, and offer consumer-facing AI tools, generative AI tools, which might have fantastic use cases. But if they're in the high-risk category, it's going to impose all sorts of obligations and legislative controls on them.
And will those regulations sort of overlap or counteract each other? Will they?
It's an interesting question. No doubt they will. I probably haven't gone into such a line-by-line approach, and I should, and I will. And then you're talking about, what's going to happen?
Yeah, where do we? And there's in the on either side.
Yeah, so I mean, we're a little bit further behind those two. They've been thinking about this for a lot longer, but we'll definitely have to think about it. And then also you have to think about a lot of the existing legal structures, the legislation, are just not fit for purpose for these things. They often lag behind the technology. We've seen that in all sorts of other spaces, and this is no different.
Do you think that given the impact the technology's had in such a broad way on society globally, that the number of cases addressing specifically these things, like, for example, New York Times took OpenAI to court over copyright claims, things like that, do you think more businesses are going to look at targeting these, I guess, conglomerates that are training their models specifically with the view to expedite the legal frameworks and the system in doing so?
Yeah, I think so. I mean, there's lots of different ways you can attack it, right? If you feel like your business model's under threat from these things, like if you think about a lot of the media, and geoterrorists, you think about how Facebook got regulated and some of the platforms got regulated here a couple of years ago because they were taking away eyeballs from the original creators.
Yeah.
The Ages of the World, the ABC.com, and those sort of places. And so, obviously they then had to do deals with those.
And they're not renewing that deal.
And they're not renewing those, tweak their algorithms and et cetera, et cetera.
And I think that's the nefarious part of signing a deal is the algorithm will change the course of that deal. So it doesn't necessarily mean what you sign is what you get.
But adapt everyone, they'll adapt their business models. But yes, you no doubt will see more of these sort of actions by large media companies, and maybe class actions on behalf of many media companies against the Microsofts and the AIs of the world for copyright infringement. Depends how the case plays out and how they plead the case, and the US is slightly different to Australia, of course. But typically, you can't pull back what's already been done, right? Like it's a bit like a breach of confidentiality. Once it's breached
and it's in there, it's in their data set,
right? But you might be able to sue for damages, or again, here's the counted profit or whatever it happens to be.
And how does that, I guess, play out on the international stage? So taking that same example in the New York Times and OpenAI, since part of Microsoft, they are present around the globe. So would that have any impact or sway on, say, then the ABC here in Australia taking OpenAI? Does this have potential?
Yeah, look, it could definitely be a test case. And the hard part would be, in a lot of these cases, if you've got a suitable test case that paves the way and it's successful, then it often leads to outcomes for other people who will be able to show a similar case without having to go through a court case.
Even though the, I guess, legislation is in the jurisdiction.
Yeah, definitely. Now, obviously in Australia, it could be a bit of a different situation because, the legislation and, the interpretation, the common law is a bit different here. So you could have a different outcome in Australia than you do in the US. Then it does
set the precedent and then.
Yeah, but you would definitely, if a case had been run or won by a media company in the US, then, an Australian-based media company may look to leverage that as a sort of precedent of types, but obviously a person from a foreign jurisdiction, it doesn't hold a lot of weight in Australia. You need to develop Australian-based precedent, or more particular, maybe more so from other common law countries or more similar countries like US, yes, UK particularly is also a very strong sort of base of reference. And then you've got to think, okay, you have to prove the loss. What sort of loss would they have? Yes, the cost of running such a case. Yeah, the US is famous for having very high payout and damages bills, being very litigious. So, if you think about some of the defamation actions,
that is made up money.
Very different. So, it is of quite a different system in many ways, but some of the principles of the base.
I'd like to talk about something it's pretty serious, but can also be a bit fun. Generative AI with deep fakes, voice printing, things like that.
Yeah.
There's so many consumer or
your last episode.
There's quite a few consumer level tools out there that are really good.
They're amazing.
And they're cheap. They're very cheap to use, and they're almost word perfect. You listened to one a little bit before with one of our tests, and it sounds pretty good. What kind of legal avenues do people have against that? If someone was to steal my voice, my face, or in the case of a celebrity?
It's a really good question. I've seen these. I've seen DJs, make up something that we use in their sets, and they run it through a tool. It may sound like Eminem rapping, but something he never raps. Yep. Or Taylor Swift doing something she would never say. And all these sort of the whole lot of permutation to get imagine. And look, the thing. It's a great fun. Yeah, it's a very, very fun. Right, it's really fun to play around with. But to your point of what are legal issues, I must say I'm not deep in the detail of this. I don't believe there's you don't have copyright on your voice, right?
Which are interesting. That almost like biometric data is kind of considered that personal information, sensitive information. But the voice, kind of not.
Yes.
In conjunction with other data points.
Yeah, and I mean, there's slightly different areas of the law. So one's kind of like talking about privacy law, and we don't necessarily have a toward the breach of privacy in Australia. Right. Other countries sort of do. But also, so if you think about a musical recording, there's different types of copyright in that recording. But the voice itself isn't
not so much.
Is it
created?
It's not the recording of the voice doing something would be, but the voice itself isn't. It's a bit like there's no privacy in the public spectrum. You can walk around the streets taking photographs.
Yeah.
So you don't have that right of privacy per se. So, but if the model was being used to imitate a voice that was singing a song that was subject to privacy or copyright protections, that might be an interesting test case, but often it's not. Right?
What if it was, for example, a scammer gets caught using generated voices to scam people, and it's a likeness of an Australian celebrity. Let's just go Russell Crowe for it. Russell Crowe is calling everyone from the ATO saying that they are unpaid fines and stuff.
Yeah.
Is it more of up to Russell Crowe to pursue shutting that down, or is that something that the law itself can get involved in because they're clearly using someone else's likeness?
I think it's less around the voice. Yeah, I think it's more around the
intent,
the illegality of the act. Right. So when you get back to utilizing, you might have an issue around using particular telecommunication systems, a crime or something like that. Right. There's lots of different ways.
It'll come back down to that original crime.
I think when you try to rip someone off,
out the crime, not necessarily how you did it.
Yeah, I mean, people are if people have done fake voices for a long time, right? Before AI came around, we're just finding different ways to do it better.
Yep.
Right.
But it's interesting because I used to work in the film industry, and you film something or you record someone, you get a release form, and that generally has how long you can use it for, what you're using it for, things like that. And if you sort of breach that, the person then has recourse to get lost money back, things like that. And, all of the strikes, the Screen Actors Guild strikes in the US, for example, were based around, we want to take a photo of you and then recreate you and use you forever as an extra in our film, that kind of thing. And usually it's extremely problematic. It takes away jobs from people who are struggling to make it in that industry. But also, when you are in breach of that as a normal person, it becomes you've used my likeness without my permission. So I wonder if that will sort of bleed across into the deep fake.
Yeah. I mean, I think, you're coming back to what we all need to be thinking about. The propensity of fake news. I hate that term because it's been so misused. But, disinformation, misinformation, and that can be both text form, it can be in a visual form, it could be in audio form. There's lots of different ways. And obviously, big election year around the world this year, and it's quite concerning to think about how this is going to be used, weaponized.
On that note, Midjourney, one of the preeminent image generators on the internet, they actually just banned the use of outputted images to generate either images of Trump or Biden because of that very real concern around election interference.
Yeah, but I mean, there's US, there's cases going at the moment around, AI, generators, so visual generators, things like Midjourney, Stability. And does AI generated art breach the copyright based on it's been trained on particular art, right? And it's representing a bit of a likeness sometimes of some of that copyrighted material. So it comes back to whether or not is the source material subject to copyright? Is that copyright still being breached or breached anyway by what you're doing or what you create and how you're using it?
And they're all going to be relevant questions. What I really like about the industry is it very much reminds me of cyber in the adversarial nature of the back and forth cat and mouse chase. You have people defending and then people like breaking. And we've got them defending it back and then breaking again. I find it a very similar landscape with those creating the models and like being like, just as much data as I can get versus those being like, but not my data though. And it's something that Beck and I discussed both in our previous episode and kind of leading up to the creation of this podcast. But there's a lot of tools coming out now that actually poison the data sets that these tools train on. One of them is called Nightshade. And what it does is it has like a layer of code in between the actual image that gets input to the LLM, and it provides a not real case for the image. So the image might be of a dog, but the code shows that it's an, in quotes, image of a cat. So when the model ingests it and then tries to make an image of a dog, it actually produces an image of a cat. So the model becomes completely useless. You can't actually use it. So it intentionally poisons them so that they are not functional with the idea to protect copyright. And I think that's something as well that hobbyists and artists and people that are of that mind that copyright is, something that needs to be protected, irrespective of how big or small you are. That's going to become a lot more common. And I do wonder to what degree those things can also be included in things like faces and voices, like adding those breakers in between. So
you can have the stickers that you put on your face to stop surveillance cameras from ingesting your facial recognition.
Absolutely. So there's already, I guess, physical things that mask your real physical appearance from some of this technology. I do wonder how long it is until we start seeing more of those in the digital space, protecting us from these digital surveillance tools.
Yeah, I think that's, in any area, there's innovation, and then there's the next layer of innovation to respond to that last innovation. There's offense and defense constantly playing off each other.
Kind of makes it better though. I mean, that's why technology is born in war.
Yep. Yeah, absolutely. And, there's going to be a need for these types of tools to combat some of the issues and the threats posed, some of the potential IP breaches and infringements that are going to happen or already happening. So companies will definitely get smarter and they'll get wiser. And hopefully it'll be interesting to see how this goes. And I mean, look, we see it no differently in cybersecurity, right? And every time, threat actors tend to stay a little bit ahead. We got to catch up. You got to keep moving.
They don't have the red tape.
What you do now is compared to 12 months, 24, 36 months ago is quite different.
Absolutely. And I guess that kind of leads us into the view of what do you think the state of the legal system is now, like laws that are in place currently that within this time next year, they'll already be completely out of date or not relevant or won't provide as much protection as the previous intention was?
Yeah, it's a good question. I mean, fundamentally, I think there are lots of adequate laws in place around confidential information, confidentiality, and intellectual property fundamentally. It's really going to be the challenge is the application. I think number one is the application of those laws. How do you prove your case? So the New York Times case is a case in point. But how does someone prove that their copyright or their particular intellectual property right has been infringed by one of these tools.
Will these cases go beyond just the straight copyright to also include a bunch of technical affordances of the technology that litigators may not even have access to?
Yeah,
So
potentially.
I do wonder to what degree, like, are the laws of how you even bring something to the court relevant
argue
for this? How do you even raise it as a thing?
I think that's right. I mean, I think some of the regulatory responses have been to get better understanding of what the actual law does, how it works, what works as sort of DNA, because without understanding that, then it's hard to understand what the impacts and consequences are. It's all conceptual. But obviously, that's all highly proprietary sensitive information, right? So there's a bit of a dance around some of those issues.
It is this interesting thing of you've taken proprietary information, but your information is proprietary. So what are we doing?
Well, there'll be this steady, like every court case, there'll be this dance around evidence and subpoenas and requests from one party requesting information from the other about, okay, we need to understand X, Y, and Z. And there'll be lots of legal skirmishes around this for by companies with very, very deep pockets. So, I think that's one. I think the other one, obviously, is, people are leveraging AI a lot in terms of employment. You're seeing a lot more people having, employees being screened, or potential candidates being screened using these types of tools, the bias involved in those tools. You could have potential biases or legal issues because you are the tools are biased in a way that's actually in breach.
It could be an HR kind of issue.
Exactly, a breach of an anti-discrimination law or something like that. It might be collecting information which is sensitive information around someone's religious views or something like that. In a way that's not appropriate. So, there's some interesting ethical and legal questions in relation to how that could be applied for, say, employment in the employment space. I mean, the underlying bias in these tools is quite interesting because it's been trained on data which has probably got inherent biases in it. So the idea of, provide me an image of a leader type thing, would typically bias to a white
man in a suit.
Exactly. Do you know?
As soon as you add a word like compassionate or emotional sensitive, it's a woman suddenly.
Exactly.
And you kind of, I always wonder if those biases are not necessarily observable from our remit, because we see all this disparate and disaggregated data, but when the tool looks at it from this like high level pattern recognition thing, the bias becomes incredibly obvious to the tool.
And it's seeing more of this and less
seeing it. Yeah, it's seeing those apparent, those repeated occurrences, and it can actually like join them together really quickly. Whereas we have to sift through all of the material, remember, put it together in our mind. And I do wonder, not saying that it's intentional, but I do wonder how much the bias is completely unintentional, just based on how we perceive it.
What we've actually produced in the past.
Exactly. I think that's right. I think you get back to the issue you had before, what's called the Habsburg AI. Where it's just eating its tail, right? And it'll sort of get down to, a very small set of, what represents this particular thing. The old adage is, these are probabilistic models, right? That's all it is, right? It doesn't understand what it's doing effectively. It just knows, after the word apple, there's one of the more likely words would be Kate or pie, probably not going to be cat, or something like that, right? Yeah. And it's just these probabilistic models, right? And so, they can change some of that, I presume, without being too, I'm not very technical, but it'll be interesting to see how if they're forced to or they're incentivized to.
The speed of the probabilistic determination as well, like, when ChatGPT first happened, everyone was like, oh my God, it's so quick. And now a year and a half later, they're like, why is it taking so slow? Yeah, so it's so taking its time.
Type in 3 sentences.
We all thought that it was going to like completely, kill our jobs a year ago. And now we're sitting here being like, it's not happening as quick as I thought it would. Yeah. It's like amazing how quickly we adapt to.
But it's the boiling frog syndrome where, and the last 6 months we've been like, oh, this is weird and fine,
getting weird.
But now we're like, oh, this is fine. I now use this for this and this for that. It's amazing. And 6 months from now, it'll be completely different again, and we'll still talk about it.
I've sort of thrown in all sorts of prompts to try and understand it. And if you look at a lot of big law firms these days, the juniors and the grads coming into them, they are very skilled in utilizing technology. The technology in the law has a big interface now. Some of the older older practitioners and partners are not as au fait with that. The classic old partner law firm that need to, over an email account. But they are becoming prompt engineers, right?
It's on their resume now.
Yeah.
People are putting that on their resume. I am a prompt engineer.
Yeah.
I have experience.
Yep. And it will become a big skill set.
Yeah.
Just before we kind of wrap up, because there are a couple of fun questions I'd like to get to, but on the note of nothing can be copyrighted without the creation of a human, can prompts in any way kind of be considered in some way the human intervention? Because you kind of indicated that the human has to be there to create a thing to be copyrighted.
Yeah, I mean, humans can I guess I'm saying what I was trying to interpret there is to say humans could if they're generating stuff or creating things by prompts and things like that, it's a different use case. But something a program coming up with its own innovation,
Right.
it's of itself,
That
is a different, right?
I totally see what you're
And if there's any sort of deep sort of trademark or patent lawyers out there who think I'm telling complete, porcupines, please email.
Yeah.
I would love to know if people are looking to, I guess, copyright fonts and things like that. It's kind of like this,
Like a prompt library.
like a prompt, and almost then you can put together a book and then sell the book, and like it kind of comes down to that whole like, is HTML code proprietary if I use the same code that you do to display an image?
Yeah.
If I change a word,
Yeah.
is it no longer proprietary? It's interesting.
There's a level of obviously very difficult to it's very difficult to get protection over just common language and words and stuff like that. There's some famous cases around can you get legal protection over the particular color used for Cadbury?
Yes.
The purple. Yes, it is a particular color.
There's a lot of color.
What's it? But then so it's it's about how this level is distinguishment and all these types of different tests, right? So there's a lot of different tests that apply to these.
Well, it sounds like a lot of fun.
Look, I think this is going to be an ever evolving law, and
They're looking for you.
yeah, it's great. Like, it's just like and look, I enjoy the law because it is ever evolving. We've had, as I said, technology and evolved to the cloud and all the different issues. Cybersecurity probably wouldn't be nearly as big a thing without all the adoption and transformation of society that's happened through cloud and cloud enablement. And this will be the next phase.
Now, well, on that note, given your experience in the realm and obviously working at CyberCX and in such a head of such a decision-making capacity, what do you think organizations should be doing to get ready for this AI wave coming for them, whether they want to or not?
No, great question. And look, this is where the rubber hits the road for a lot of organizations. I mean, I think first and foremost, I think it's probably organizations should obviously be aware and getting a good understanding and knowledge about where AI is going and how it can impact them. I think they should be giving guidance to their employee base around the appropriate use of these tools. Some are taking the approach of you may not use this. Some are taking an approach of use it for these limited purposes only, but it doesn't replace human intervention and blah, blah. There's all sorts of different ways in which that can be applied. But I think it's having a conscious discussion and decision about how that can or can't be used, and the rules around use within the organization is essential, because unless you sort of are clear about what the rules of the road are for your organization, then people won't know how to use it and follow it. And also then, you'll end up at some point in quite a difficult situation. Absolutely. I think you've then got to communicate and train your staff in relation to those matters. So we're doing that here. We've had, an AI policy in place now for some time. Our CSO, Chief Security Officer Mark Hoffman, and prior to him, Phil Koenig, go out and talk to staff at town halls and things like that about use of AI and how it's appropriate to use it. And then also talking about some of the benefits and ways in which we're looking to harness it. Yeah. So that's first and foremost. I think second part is then, if companies are thinking about, okay, well, how can I then use it for our own productivity purposes or doing things ourselves? Again, understanding where the models are trained on and some of the issues around that. Understanding if they're going to use some of these tools, where their information is going, and whether or not they're comfortable with that, or whether or not they're breaching any confidentiality, personal information, and trade
Data sovereignty as well.
Exactly. So where's the data going? So I think you've got to be cognizant of that. But by all means, people should be out there thinking about how they leverage and at least come to grips with this. because it's going to be here. It's only going to get bigger and bigger and bigger. Whether it gets bigger and better is a bit of an open question. But it's here, probably here to stay in some shape or form.
I don't think it's going anywhere.
Yeah.
And I guess what view do you have on this being and it'll differ from organization to organization with the number of employees and the industry, but driving it down from a top-down approach or from a bottom-up approach, in that employees raising ideas of ways to use these tools to the org and the org assessing their suitability, risk of that nature, or should it be the experts decide and inform everyone this is what we're doing?
Look, I think there's probably a mixture of both. I think from a policy and governance level, it's always going to be a fairly top-down approach. This is the organizational stance on these tools, and that's often not detailed. It's often kind of sets some ground rules and some sort of guardrails.
Align understanding.
But innovation can come from anywhere, right? So you don't want to stifle people's ability to innovate and create. Often it's not the most senior people who do that all the time. Often that comes from everywhere, right? People tinkering around, people doing something at home, whatever. And it's no different to when people's come up with a bit of a bit of code or something that they've worked on. And they think, hey, this is actually really valuable for my work at you guys' institute. So we have an approach to employees generate IP outside of work in their own time. Is that something we want to leverage? Do we get a license to it? What type of deal we do? Probably no different here. If you come up with a great idea, utilising one of these things, and there's a business benefit, then again, run it through your processes. Think about privacy impact status, assessments, understand where the data's come from, what data's going to, and all those types of concerns if you go and tick off before make a decision in a way.
Amazing. Final question, I suppose, is what can just general individuals or citizens do or stop doing to make sure that they're not doing things?
So you get your card number.
Yeah, but never done them, maybe don't tell it what your mum's maiden name.
Exactly, yeah. Don't put don't store your passwords in there. Again, probably no different to some things we've touched on already, but have an awareness of the fact that any of data that's publicly accessible is a training set, Tom, right? Mm-hmm. And that's no different for your own personal information out there. So be aware of what you're putting online, and this is just good.
It's presumed anything we put out there is now
exactly done. Be conscious of what you're putting online because it's very difficult to get off. And while you might be able to pull something off, your Instagram account, there will be something somewhere.
Yes,
so think about that and think about the long-lasting impacts that could have to yourself or your professional life or whatever happens to be those around you. I think second part is, again, coming back to that misinformation type idea, disinformation type idea. Unfortunately, we do have to be alive to that. And so think about where your reputable data, information comes from, and what the source that the information or their biases might be. So it gets back to all those classic sort of things you do in English at school. Who's the narrator? What's their bias? What picture they try?
Are they unreliable?
And I think no different here. So you've got to, I hate the idea that you can't trust everything, but you probably can't. And again, but you've got to choose your area. What do you think are the reliable providers of your information, those information sources, and understand what they're doing to combat these issues.
It is the legacy none of us thought we would be leaving behind.
I think I've leaked all sorts of inappropriate PII. That's my face about 10 years, so why go into that right now?
That's another. Chris, thank you so much for dropping by today. It's been a pleasure having you with.
It's been great chatting to you guys. Thank you very much.
Thank you so much for your insights. And we look forward to being able to continue this conversation, hopefully in another session. But it's been great to get a sense of what legal considerations and now security considerations, as it seems like it's no longer a black or white, this is legal, this is security. They're very much tied together now as far as the review and dissemination of all that information. So, thanks for your expertise and looking forward to the next time.
See you next time.
Yeah, come back soon.
Bye.